Welcome everyone. Feel free to introduce yourself on the chat. As we begin, my name is Maureen Ochako. I'll be co-moderator for this session. Feel free to type in your name and the organization you come from into the chat. I can see we have our panelists, so Brenda and Christian, welcome.
Thank you very much, Maureen.
Nice to meet you all. I think we'll begin in a minute, just letting everyone settle in. Janet, please accept the people who are waiting on the lobby. Nice to meet you, Leonard Chacha. See Lizzie from University of Eldoret, someone from Masai Mara University. Lovely to have all of you. We're ready to begin our session. Like I said before, my name is Maureen Ochako, a program implementing manager from ViKtoria Ventures. And we're happy to have this session where we're discussing about IP protection and management. So perhaps before I start, I'll just hand it over to Agnes to introduce about KeNIA, what KeNIA does, or what is the role of KeNIA in all this.
Thank you, Maureen. I just wanted to confirm that Dr. Tony is not on the call. Have you checked?
Yes.
If he's on the call before I speak and my CEO is here.
He's not
all right.
there.
Good morning, everyone. My name is Agnes Tsuma. I'm from Kenya National Innovation Agency. I'm in charge of innovation commercialization. And today we are working very closely with our partners, FCDO, the UK8, and ViKtoria Ventures. And this morning we are running this webinar on IP and management. And just to bring us into context, I would like to just give a very brief intro about KeNIA. So KeNIA is a state corporation, and it's basically mandated to develop and manage the national innovation system and facilitate taking ideas to market. And so we ideally do come up with interventions that then support the innovation ecosystem in a 3-tier. And we look at it from a national perspective, an institutional level, and at the individual level. For us to be able to support the national innovation ecosystem, we need to look at it holistically. So at the national level, what regulatory frameworks do we need to put in place that would then create an enabling environment for the country to be able to be more innovative and actually innovate further and, create the opportunities in the market in terms of products and services? What regulatory frameworks do we put in place? We have some guidelines that we put in place, and we actually launched them last year in December. These are commercialization guidelines and guidelines for coordination of incubation hubs in the country, or innovation hubs in the country. Okay, so that is at the national level. We are also working towards developing a 10-year roadmap, innovation roadmap, which will then guide the country towards, activities basically around the innovation ecosystem, right from the funding for startups to, regulatory frameworks that would make the startups thrive in the environment. So much all around, even priority areas for the country where people can actually focus and, invest when it comes to investors. So that is about the 10-year roadmap at the national level. At an institutional level, we have come up with interventions. And these are basically, for example, we talk about institutional commercialization support program. So we are working very closely with institutions to support them to, put in place structures and systems to be able to facilitate commercialization in the institutions. So we are doing that very closely with support again from the FC. And we have been doing this for the past 1.5 years now. And we envision to do this to be able to reach out to as many institutions as possible. Okay, so at an individual level, we have just started, the first cohort of research to commercialization. And thanks to this project or program, we have this webinar. Okay, so through the R2C program, and we really appreciate ViKtoria Ventures for coming up with these webinars because they're very informative and they really help not just the R2C fellows, but the general public, because this is put out in the public and people get to learn. And maybe Maureen will be sharing a little bit more about this. They have different topics every other month, which means that you get an opportunity, as much as you're not benefiting from the R2C program, you get an opportunity to get a lot of information, which can help you in your innovation activities. So we have the R2C program. Apart from that, we have the KeNIA Innovation Reach. This is an online marketplace where we try to bring together the demand side in the innovation ecosystem and the supply side. So the supply side is the researcher or innovator who has a very innovative idea and they want it to reach the industry. And on this other side, we have the demand side, and this is the industry player, the private sector, development partner who needs a solution. And so we have put that platform in place. We are in the third phase of developing this, and mainly the major campaign is around bringing on board the supply side of the market. And apart from that, we're trying to develop a mobile app for it where you'll be able to access that service on your phone. So much about KeNIA. I'd like to stop at that point. Thank you very much, Maureen.
All right, thank you so much, Agnes, for setting that pace. And then I'll speak a little bit about ViKtoria Ventures and then just go right into the program and then we go into the webinar. So ViKtoria Ventures does many things, but what is important for us today as researchers is that ViKtoria Ventures has, I highlight two main things. First of all, it's a management consulting firm, which means they bring a breadth of experience in terms of sales, marketing, business management, business modeling, canvas, etc. But then of importance, perhaps I would like to just highlight that they also are responsible for managing a network of angel investors, which I think if you come from this element, you'd know that one of the problems that we are facing, our researchers are facing is, they have good researchers, but then the connection to the investors is where we find to have a gap. And with ViKtoria Ventures comes with that breadth of experience of investment management, direct linkages to funders for their researchers. So without spending too much time, allow me to share my screen. Someone is, please make sure that the person who's speaking. Okay. All right, I'll just take
Information management.
Please mute your microphone. So this is today's agenda. We've already done introductions. I'll just take us through project overview, 2-3 minutes, and then we'll go right into the panel session. We'll have a question and answer after that, as well as announcements and closure. And we have these webinars every month. And Agnes has already spoken about ViKtoria Ventures, about KeNIA, and I've already mentioned a little bit about ViKtoria Ventures, which is a fund management firm with a focus on enterprise financing. So this is the R2C program, Research to Commercialization program, and it has 4 main elements. We have the R2C Accelerator, Research to Commercialization Accelerator. We have coaching. We have webinars, which is where we are today, and we'll be running these webinars until December. Then we have training of trainers, where we're looking to strengthen the institutions by creating R2C programs for the institutions. But importantly, we'll be calling out interested applicants to apply for this call so that they'll be the focal person for the R2C within their institutions. And then how we'll be doing this, we'll have 2 cohorts. This program runs from last year, December, to the end of this year, but we'll have 2 cohorts. For example, for the R2C accelerator, which is targeting 20 innovators, we'll have 2 cohorts. We have the first cohort already onboarded. We'll be having the second cohort running from July to December 2023. The first cohort has 8 applicants, so we still have room to onboard 12 more applicants in the second phase of the cohorts of the program that runs from July to December. And then for the TOT, where we're saying we want to strengthen the institution by ensuring that they have a focal person who's responsible and who understands the research to commercialization process. And this person will undergo a training, and we're looking at 30 participants. The call for these participants will be dropping next week. It will be all over social media. And then to ensure that we also have that gender bias, we are in partnership with Mawazo Institute to ensure that we train 20 female researchers, matters research to commercialization. And just to highlight a little bit more, this is for the research to commercialization accelerators. We're focusing 30 researchers. And what does the program entail in terms of training? So we'll train on different elements. We'll have 3 weeks of training, and then we'll have coaching. We have excellent coaches depending on different thematic areas, and they'll be providing 10 hours of coaching to these researchers. And then there's the element which I would like to highlight majorly, is just the connection to the investors. So they'll be working with an investment and commercialization manager to understand where they're facing the bottlenecks, or to understand how they need to move to the next step and be able to secure funding. This includes pitch preparation, pitch deck, etc., and then the actual connection. And then in terms of the TOT, we'll be having 30 participants as well. And the call will be coming out next week for the first cohort. And they'll undergo different aspects of R2C based on their needs or based on where they are. And then we'll have a coaching session as well. And then at the end of this training, we'll be able to share with them a toolkit, a reference point, while they're setting up the R2C programs within the institution, that they can refer to this. And then, of course, I already mentioned gender. We'll also be working with gender with Mawazo Institute to ensure that we also train female researchers. We're targeting 20 female researchers. And yeah, and then we also will be running webinars in concurrent with them. And then just to highlight, this is my last slide, we'll be having the next webinar session on the 9th of February. And we have different webinar topics which are based and informed from the researchers' needs assessment. And that brings us to the end, and we can now fold our sleeves and get ready to why we got here. So I'll just stop sharing my screen. So we have, one of the topics we wanted to discuss was IP protection and management. And yeah, maybe I'll just invite the panelists and the moderator for this session, that's Agnes Tsuma, to unmute and perhaps introduce themselves and hand it over to them. Introduce themselves, so we can, Agnes, you've already introduced yourself, so we'll go to Christian. Christian, please introduce yourself.
Sure. Good morning, everyone. Thank you for having me. So I am Head of Technology Transfer at the University of St Andrews in Scotland in the UK. So I manage a team that look at and decide on the commercialization process of university research. And as part of that, we manage the intellectual property protection, filing, prosecution, and licensing.
Nice to meet you. Brenda?
Good morning, everyone. It's a pleasure to be here today. I'm a partner at CFL Advocates. It's a boutique law firm where we deal mainly with IP law, corporate commercial law, real estate, and financial services law. I practice IP law, so my work basically involves IP filings, IP prosecution, and IP enforcement.
Nice to meet you. I think over to you, Agnes, for the session. So feel free to type in your questions as they proceed.
Thank you very much, Maureen, and good morning, everyone, once again, and welcome to this session. Well, our panelists have introduced themselves, so no need to get into that. We'll dive in straight away. And I'd like to take this opportunity to welcome Brenda to start us off. And my first question is very simple. I, as an innovator, we as innovators, why should we protect our innovations, and what type of IP assets or what types of IP are actually existing at the moment in Kenya. So over to you, Brenda.
Thank you, Agnes. So I think as an inventor, as an innovator, your key purpose is to generate revenue from your invention. And so IP is one of the tools that you can use to generate revenue. IP protection will give you that assurance because it will provide you with an edge against competitors. No one will be able to use or copy your invention without your permission or consent. And when it comes to revenue, you can license your innovations, you can use them as security for loans, you can sell them. And so that is the main reason why you should protect your IP. When it comes to the types of IP, there are many, but I'll just mention a few. So I think for innovators, especially in the research field in universities, most of you focus on patent protection. So there is patent protection. You can register an utility model. Some people call it a minor patent. You can have a trademark protection. You can also do industrial designs, as well as plant breeders' rights. So I think those are the ones that would mostly work for researchers. And I don't know whether you would want me to just discuss them a bit or it's just sufficient to mention them.
For now, let's just mention them. We'll go deeper if need be. Yeah.
All right.
Over to Christian, I'd like to hear, are these the only, type of patents? And do you feel like most of your innovators actually do patent? But why, in your perspective, why do you think the innovators should patent? Is it really, really necessary? And based on your experience out there, what kind of patent or IP assets do we have?
Yeah, thank you. It's a good question. So I think the first thing to recognize is that in a lot of research and a lot of ideas, a lot of inventions or technologies, there is often multiple types of intellectual property or IP that may exist and can be protected. The reason that certainly we as an institution and most UK institutions I think favour patents as the main module or main flavour of protection is I think really, as Brenda has mentioned, that is the one that protects the invention. They are specifically designed to protect the way an innovative idea works from a technical perspective. So whilst the other types of IP have value, they tend to have value, I think, for lesser elements for research, and they're often more valuable for a later stage business. For a trademark, for example, which protects a name, it's very useful for once you're established, perhaps as a business, and you have your name or your logo has some significant value. But the patent, I think, is absolutely critical. So that's really where we focus a lot of our attention.
All right, great. Thank you very much. And if I'm hearing you right, both of you talk about revenue. And apart from that, it's very key for an innovator to actually note you're protecting the idea that is unique. The technical aspect, that thing that is unique about your idea, that is what you're protecting. So very keen to note that. And yeah, that helps, that sets the pace exactly on why we are doing this. And maybe now my next question would be, and I'd like Brenda to start us off, can we, break it down, the associated costs of patenting? Now look at it from a local perspective. I believe we have somebody from KiPi with us. What are the costs? And that is not just the provisional, everything locally. And if at all I choose to protect my IP beyond Kenya, what would it look like in terms of costs? And because you're a lawyer, probably for now, you can separate the professional costs from the actual costs of, filing the IP. Over to you, Brenda.
Okay, thank you. So I will discuss mainly the official fees that are incurred for these filings. And as you said, there are different parts that you can opt to take as an inventor. We can start locally, which means filing your patent in Kenya through KiPi. So, and first of all, I should just mention, as a citizen of Kenya, you cannot file your application for patent outside Kenya without getting permission from KIPI. So you may opt not to start with Kenya, but you need to get permission from KIPI before you go and file elsewhere. So if you're going to file at KIPI, ideally the costs for filing up to grant for a straightforward case should not be more than 20,000. I think it's about 19,000. So you will have to pay for the application when you file your request with your claims and descriptions. And then you'll need to make a request for substantive examination once the request has been reviewed and all the formalities have been met. So there's a fee for substantive examination. And then after that, you will pay for a certificate and publication. So patents are usually published twice in Kenya. Once you file, it is received, a filing number is given, it will be published. That one you will not pay for. But after the substantive examination, and it is granted, it is published again, there's the fee for that certificate and for publication. But in total, these fees for a straightforward case do not go beyond 19,000. However, it is not very likely that you will have a straightforward case. Most times, because of that aspect of a patent needing to be new, needing to be very unique, you will get some responses after the substantive examination, which would mean that you have to make some amendments to the application and all that. Another route you can pursue is through PCT. So PCT gives sort of an international filing opportunity. PCT is an agreement where we have many countries that are party to it, I think about 141. So when you're filing through the PCT, you would file your application either directly with WIPO. WIPO is the World Intellectual Property Organization, or you can use KIPI as a receiving office. So PCT does not ideally grant a patent, but it will give you an opportunity to get your patent sort of reviewed. You'll get an analysis as to patentability, and it will also give you an opportunity to file one application that will enable you enter into many countries at the same time. And you can also do, so for the PCT filing, if you use KIPI, you will have to pay them a transmittal fee as the receiving office. And then other fees that you file are the international filing fee and a fee for a search. It's called an international search. Those ones you will pay directly to KIPI and they will forward them to WIPO. If you require your patent to be examined further, you can also pay for a provisional examination. Of course, they will give you aspects which you can correct before filing nationally so that you know whether it is new, whether you need to work on the industrial applicability of your patent application or not. You can also do a regional application through ARIPO. Kenya is a member of ARIPO. So what ARIPO does, they will receive the application and examine it as to formalities, and then forward it to each member that you have designated. I think the members of the ARIPO protocol of ARIPO are about 19. And those ones that are members of the Harare protocol that governs patents, maybe 18. So you can decide to designate all 18 of them. Once ARIPO has done the formality examination, then the application will be forwarded to the different countries for substantive examination. So the different countries will do their own examination and get back to you. That is another route you can use.
Wow, very, very interesting stuff. Some of these things I'm learning today, interesting. Thank you very much, Brenda. I'd like to refer the same question to Christian, just to tell us, how do you do it in your country? What are some of these costs? You've heard what we are paying locally and probably the duration that it takes to get a fully, patented, get through the whole process. Yeah.
Yeah. Thanks, Agnes. So I think the first comment to make, I'll make a couple of comments. So firstly, Brenda has talked about, filing in different countries and the PCT international kind of system. And just for clarity, the reason we're talking about that is patent protection is secured on a country by country basis. There are some frameworks where you can get multiple countries, but the principle is, if you patent in a country and you get that patent, then you have protection in that country. If countries that you don't apply for and get a patent in, you have no more protection than anyone else. So you're not able to stop anyone else. Anyone can work the invention in that other country. So that's why it's quite key that we're talking about other countries. I would also say that most countries are quite harmonized or aligned in terms of their system. So likewise, as a UK applicant, a UK owner, we are required to file the equivalent of KeNIA in the UK for our first filing, or we need to get permission to file elsewhere. We have the same process of have an examination. It tells you about the patent, and then it goes forward to grant. So we as an institution will start in the UK. Official fees tend to be around $300-400 US, and that covers you from start to finish. We don't have kind of additional top-up fees until after the patent has granted. I think the other thing that's really key to mention, and this feeds into our strategy, is patents in a lot of jurisdictions can take anywhere from 2 to 5 or 6 years to grant. So although the costs are quite high if you file in multiple countries over a period of time, actually to start the process, to get the first 1 or 2 years covered is not prohibitively expensive, and that then informs how we do it as a UK institution. We will file our first patent in the UK, and then we'll try and ensure that in the first year or so we undertake a lot of the commercialization activity to determine if this is going to be a viable product. So we'll go out and talk to a lot of investors. We'll go out to talk to potential manufacturers. We'll go out and talk to potential partners. And if the feedback, within that first year is, yes, it's great research, but it's not viable, say from a cost perspective, or it won't work, or we can't disrupt the market, then we'll often abandon the patent at the end of the year. So we've only incurred the first year's worth of costs. So that tends to inform our strategy.
I like that, and I hope our RTC fellows are hearing this. Yeah, we start off, we do some little bit of, Christian, you have preempted my last question, but anyway, very good. It's been a very interesting question people keep asking. So before we get to that point, I appreciate the fact that you brought this up, and we'll be discussing it further in our last bit. But my next question is more about IP management. IP management is, yes, you have now filed, you have if it's a patent or a trademark, managing and utilizing, monetizing, ensuring that you're actually getting the value. Why did you protect it in the first place? And then how do you benefit out of it? So then I'd like to hear from Christian, then we'll move to Brenda. Same question.
Yeah, sure. I'm happy to comment on that. So I think in terms of what will happen along the process, I think it's critical to get your patent filed before you disclose anything. So it's done at quite an early stage, and then subsequently, I think what you should expect is that that there will be difficulties in the patent process, and that typically what you will end up with in terms of a granted patent will actually invariably be slightly narrower than what you filed for as your inventive concept. So I think the critical thing really is to keep moving the technology along. And certainly we often find that as you develop the product, whilst the patent is running through that 2, 3, 4, 5 year periods, actually you tend to make further improvements, you tend to refine the idea, you tweak the idea. And it's important, I think, during that process to consider whether your original patent is still relevant, and alongside that, whether you might want additional either patent protection or other elements of types of IP protection that might be useful. So I think the big message is you don't just file your patent on day one, then go away and do the commercialization and really forget about the patent. You need to keep thinking about what is my IP strategy throughout the life cycle of your product development and product launch or innovation launch. I think that's the key message from me.
What about you, Brenda?
I totally agree with what Christian has said, and maybe just to add, once you have put in your application, as you're reviewing your technology, making improvements, I think it is also crucial to try and understand what other aspects of IP you may gain from that process. So it's not like as a researcher, once you have already filed your patent, then that's it, that's the whole protection you can get. So it's critical to just through the process, examine and see what other aspects of protection you can get beyond the patents, others that are maybe faster than the 2 years that will protect you as you keep going. And also, once you start that aspect of, reaching out to the market to test waters, maybe to speak to investors, it is critical that you enter into contractual agreements that are binding, such that this technology that you have is not used against you. Someone does not go and run with it, and all that.
All right, I'd like to address some few questions, Maureen, if you will allow me, so that you don't lose the conversation, because they're quite really related to what they're discussing currently. So probably I'll start with what Stephen Gugu has just posted. So what happens in the first 2 years before your patent is registered? If someone starts using your innovation, do you have any cause of action, or what would you advise? I'll start with Brenda.
Thank you. So once you file your application, as I said, you're given the application filing date. If someone uses that invention, if someone uses that technology after that date, you have rights against them. Even though the patent has not been granted yet, that proof of filing of that application is already a measure to stop people from using it. So the only cause that someone may have is if they had used it prior to your filing. So because, as we said, there's that aspect of novelty, and that novelty will be calculated from when you filed, that there was no one using it at that point. So if someone had been using it prior to that point, then you cannot stop them from using. But if they had not, you have some sort of protection.
Thank you. Should I assume it's the same case now that even for your case, Christian, it takes close to 5 years? So at the point of the initial application, you at least have the rights. Is that correct, Christian? Maybe you can just clarify that.
Yeah, so the perspective, the EU, European whole perspective really is that, I think as Brenda said, the key thing is that no one's worked your invention before your filing date. Certainly in the EU, you can't bring an action until your patent is granted. However, what you can, when it grants and then you can bring an action, you are able to claim damages, or you're able to claim effectively loss of monies that would have been made back to the date of first publication. So there is a retrospective period, and really because of that, what often happens is you might write to a company or an infringer and say, I have a patent pending. Effectively, I can't take action yet, but if and when it grants, I will be able to come back and ask you for either your profits or the damages and loss that I've suffered. So yeah, very, very similar, just a slight tweak.
Yeah, I see the difference. I hope we are noting that, guys, so that in the event that you choose to go and protect in another country, you really need to know there's a difference. It may not be all the same cutting across all countries. I hope we have addressed that question sufficiently, Stephen. Another question is, what is the advice in terms of process? Should I start locally, then regionally, then WIPO, or Brenda? Or would you go with that from a local innovator's perspective? What would you advise? What would be your best advice?
Thank you. So I think this is really a sort of commercial decision, depending on the invention, depending on the researcher themselves. So if you are seeking to commercialize your invention in Kenya, it would be best to just start in Kenya. And as Christian mentioned, there are a lot of changes that may come up between the time you file the application and when the patent grants. So taking all that into consideration, the cost, I think it is a commercial decision that you will have to make. However, what I can say to add is once you file an application in Kenya, there's another process that I think we didn't mention for a Paris Convention, which allows you to claim priority from the date of the first filing. So Kenya is a member of the Paris Convention, which means if you file in Kenya, you have a period of 12 months and you can file in another country and still get the earlier date that you got from Kenya. But I would advise to, as Christian said, depending on the research, start small. First file the first application, see how the commercialization is working for you, and see whether it is necessary now to expand into other jurisdictions. I think we have already mentioned that, unfortunately, IP law is very territorial. So if you file in Kenya only, you're protected in Kenya only.
Thank you. One other question I have to Christian, what are the key strategies that are employed by your institution to support young researchers in the institutions of higher learning in reference to IP protection and management?
Yeah, so I'll just quickly explain the broadly the system in the UK. So the default position is that a university will own any IP or any ideas generated by its staff. So effectively, what happens is where we agree that there is commercial potential in some research, we really enter into a partnership with often the researchers or inventors, because it's very rare, certainly in the UK, that there's only one. So we sit down and agree a commercialization strategy and a commercialization roadmap. And I think one of the nice things about that, or the two advantages of that process, is that the university pays for the IP protection and takes on that cost exposure. It also supports the commercialization, which means that researchers can continue to focus on continuing their research. And the other thing is, we have in-house expertise in intellectual property. We have in-house expertise in market analysis, etc. So we support that process. So because of that, that support structure is available across the whole university. There's no prioritization for more senior researchers, and actually what we tend to find is early stage researchers, certainly in the UK, are often more keen and have more motive to engage in commercialization activity. It's beneficial for their career. They don't have a well-established research group or research position. So actually they're incentivized to try and work on commercialization. So I would say beyond that, we don't need to do that much more support and outreach. In terms of specific measures, other than having an office that supports that system, we run regular training sessions similar to this, kind of educating on what is IP, what is commercialization, what are the steps involved, and how does the process work. So we run lots of, I suppose, mini initiatives. The other thing that we do, I think, quite well, certainly in my region, is we're quite good at knowledge and information sharing across universities. We don't see ourselves as particularly being in competition with each other. So we have networks of kind of 10 or 15 universities where we will knowledge share both across researchers and across kind of professional support services, and sharing best practice, and also examples of what has gone wrong, I think is very, very beneficial. Certainly our academics like to hear from other researchers who have been through the process and have had success. I think that's very powerful, particularly to early stage researchers.
Right. I'd like to ask our last question, then we'll go back to our questions on the chat. So my last question was very simple. I'm an innovator, I'm innovating, or I'm a researcher, I'm doing my research work. And of course, in the context of researchers, there is the aspect of publication, and someone can choose to publish. So the question here is, should I proceed and protect my IP before I go ahead and commercialize? Should I start off with commercialization? Then based on how things are moving, then I decide now I think I need to go ahead and protect my IP based on my commercialization processes and pathway. So what would be your advice? Maybe I'll start with Brenda, then we'll go to Christian.
Thank you. My advice is that you should protect first before you commercialize. And this is just because of that entire aspect we've been discussing of novelty. Once you commercialize and it is already out there in the market, there's only, I think, a period of 12 months within which you have to file. So if you've started commercialization and you don't file within 12 months, then your invention is no longer new. You will also not get protection for it. So there's that aspect of, because the process takes too long to grant, you don't have to wait to grant, but put in your application. In Kenya, you have a period of 12 months to confirm your final specification. So you can file the application within those 12 months, maybe start to commercialize to see how it's going, and decide whether you want to file in your final specification or to just abandon the entire application. But I would advise that you first file. It's very important to get that early date.
What about you, Christian? What do you think?
Yeah. I mean, similar answer. However, the European system is even more strict. So you cannot make any public disclosure within Europe, or internationally, and then file for a patent within Europe. We don't have a grace period in the way that Kenya does, and there's a few other jurisdictions, say the US, which we do have a similar grace period. So what that means is, if you publish your research, on the 1st of February, on the 2nd of February, you then file your patent application. Your patent application is invalid. Likewise, any steps to commercialization, and that's obviously critical as well if you're in Kenya and you're looking at looking to secure patent protection in other jurisdictions worldwide. You can't take advantage of the Kenyan system to then file, let's say, in Europe. You still would not be able to secure protection. And I think that picks up on the question in the chat as well about having to reveal your technology. So the process in the UK and the process our institution is it doesn't change. It's absolutely categorical. We conduct the commercialization analysis. We decide if there's a viable case, and we decide if patent protection would be valuable. If the answer to both of those things is yes, we file a patent, then we start commercialization, and alongside that, then we publish. We never undertake commercialization or publication before filing the patent.
Thank you very much. I believe we have researchers on the webinar. We have innovators in the webinar. I mean, this is something very critical we need to note, and I felt like it's important for us to just, always have it at the top of our minds as we conduct research and all that. But then I'd like to go back to some of the questions on the chat, and I'll start with Peter Kibet. He is asking, how can I defend my IP rights in case of infringement? I think this would be appropriate for Brenda. Over to you, Brenda.
Thank you. So in case of infringement, there are various avenues depending on the IP, right? So we'll just focus on patents. So for patents, we have an IP tribunal in Kenya. That is the starting point. You would file a suit against the person that is infringing your patent at the IP tribunal. So that is a specialized tribunal that deals only with patents and industrial designs and utility model matters. So that is the first avenue. Once you get a determination, you can either, you will be able to enforce it. After that is the first avenue, but you can also go to court if you're not satisfied with the decision of the tribunal. You can appeal the High Court.
All right, I think that is quite elaborate, Peter. We have some few questions from Stephen. One conundrum of any IP filing is that you have to reveal it to protect it. How safe are you in the process of filing? Yes, and that is also a question I have. A classic example, there's a researcher who has come to our office and said they don't feel safe. I don't know if they feel like, no, they don't want to go to KIPI. Maybe if they go through us, maybe they will feel safe. So how safe are you in the process of filing? Are we as innovators in the process of filing? Brenda. And maybe I would want to hear what happens from your end as well in the UK, Christian.
I think that is the whole essence of IP protection. You have to give the secret to the exclusive. And so else from using your invention, from using that technology. And I don't understand what they mean with how safe, like KePE is going to disclose your invention. They will not do that. They do not do that. There's publication that I mentioned, but once you file the publication, after filing, once you meet the formality requirements, it's just simply saying that this patent with this name has been filed by this person on this date. The other publication will be made after grant. So after grant is when they would publish everything that pertains to the application. But then that will give you the right to stop other people, because even when it comes to enforcement of patents, you have to show that the person infringing has used the exact invention that you have filed. That can only be proved if this information is shared by KePE. But during the process of examination before grant, they do not share any information publicly.
Maybe just a follow-up question. Say today, today is the 26th, I go and file on 27th. How long does KePE take before they do the first publication?
So the first publication will be done in 18 months, at most 18 months.
Okay. Okay, wow. All right, thank you. That helps. Maybe let's hear from Christian before we quickly go to the other questions. We have about 13 minutes. Okay.
Yeah, thanks. Yeah, I think I'd make the same comments really. So the UK and most other patent systems are harmonized. It's typically 18 months from date of filing. It's also, I think, important to note that should you decide you don't want to continue your patent application, you can withdraw it before the 18-month publication period and effectively say, I don't want this, disclosed to the public. So that is always an option. In terms of how safe it is, yeah, I'd agree with Brenda. I mean, the patent office in each country is the only place you can go to get a patent in that country, and it is an exchange or a trade. You disclose the technical information, the technical secret, and in exchange at the end, you should get the patent. So there is no other route. I think one thing that is critical though is, and we didn't really touch on this in terms of what other types of IP there are. There is confidential information, there is know-how, and it's important at an early stage to actually decide if you will ever need to disclose all the features of your idea, your research and innovation. So take software, for example. If you are, let's say you've got an algorithm, let's take the Google search algorithm, for example, that's something that runs behind closed doors. Yes, you might be able to get a patent for it technically, but in doing so, you would have to disclose how the algorithm works. And actually, because you can keep it secret, but still use it and exploit it commercially, you can take the decision that actually in that instance you don't want to patent that particular piece of technology. So it's important, I think, to consider, is this something that you need to disclose? Clearly, if ultimately you're going to make a product and it can be reverse engineered, someone can tell how it's going to work, then you have no chance of keeping it secret and you're best applying for patent protection.
All right, thank you. There is a question here. Patent protection is just one of IP and takes time. How can an innovator use those other tools for protection? And what is the success rate once you file generally? How is it looking like from your end, Brenda, and from Christian's perspective? Let's take a minute each, not more than a minute, or even 30 seconds if possible. Brenda?
Thank you. I don't know whether the person that asked the questions would like us to discuss other types of IP, but I think Christian has spoke to that. Like once you've looked at your technology, you've looked at your invention, you see which type is best suited to protect it. So another way that does not involve disclosure is trade secrets, where you keep the information confidential. But that depends on the type of invention, as he has said. If it is something that someone else can just know how it works by looking at it, you best file for that patent to get those exclusive rights. I don't know, the other part of the question was on how successful it is. I think patents are very technical in nature. Myself as an advocate, I would not be able to understand most patents without getting assistance from people in those fields. So the success rate really depends on the niche that you're trying to solve with that technology that you're coming up with, and if it is really new. I don't have the answer.
Okay, I think that's a question for Maureen. Who is eligible to apply for R2C TOTs?
I'll respond to that at the end.
Okay. We have one question for Christian. So to Christian, what's your experience? Do researchers get assistance in drafting their IP descriptions? There are experts who do the drafting. And what happens when you meet an innovator with an idea that's raw? How do you get them out there to the point they complete submission?
Yep, really good question. So, so in terms of assistance, yeah, absolutely. And that's really the support and role that our office undertake. So in terms of the process, so a researcher will come to us and say, you know, I'm ideally partway through some research, which I think might have commercial potential, rather than I've finished the research and I want to publish tomorrow. It's much earlier if we start the conversation, much better if we start the conversation early. So they come to us and provide us with effectively what we call an invention disclosure form. So summarizing very briefly what the invention is, what they think is the closest technology that already published and already known, and also telling us how they think it could be used commercially. Assuming that we decide that it can be patented and we think a patent would be worthwhile, we use a firm of patent attorneys who are specialists in patents. They have an expert in each technical field, and absolutely, to be honest, what we normally provide them is this short description. Often we provide them with a draft publication, academic publication, which is extremely helpful. And that's largely all the patent agent or patent attorney needs. And they may ask a few questions of the researcher, but yeah, it actually takes very little of the researcher's time. And then in terms of supporting them through, you know, next steps and commercialization, again, we do all of that, I suppose, in parallel with them, which is the advantage of having a kind of support office for that function. So we will help speak to companies with them. We will market the idea on our portal and platform, and then if we do want to license it rather than developing a company, we will put in place the legal agreements which decide, you know, how much percentage they will get from sales from a company.
Thank you, Christian. We have one last question, then I'd like to wrap up. Maureen, you didn't give me a time frame. I hope I'm within your time frame. So is it possible to access already existing patents at KIPI website besides applications in the journal? I think this would be for Brenda. I hope it's clear enough. Thank you.
Thank you. I don't think the website has patents that have been granted, only those ones that have lapsed that are accessible on the website. If you want to get an idea of the patents that have been granted in a specific technical field, you will have to do a search and pay the official fees before that information is given.
Okay, I guess the last one is just a comment. That's a great method that they do the marketing to find investors. Maybe KeNIA can consider. All right. I don't know if we have any other questions. We have about 5 minutes. I'd like to just do a wrap up very quickly. Just in summary, based on our discussions, we've gotten to just understand some bit of the types of IP assets that are existing, and how about the process of application of the IP in general, and you know, the duration that it actually take, the associated costs with the filing the patent or the IP, protecting your IP. But then something very key, I'd like to maybe just give it as a wrap-up point, is you really need to understand your invention. What are you trying to protect? Do you need to probably go the utility model way and IP, or do you want to go the trade secret way? It all depends with the kind of solution you're coming up with, the kind of technology. Would somebody easily be able to know what you're doing such that they can easily duplicate? And if that's the case, then you need to go the, a patenting way. And of course, this session wouldn't be really sufficient to go through all the different types of IP assets, but this is just an intro. We have an opportunity to learn more through our academy, KeNIA Academy. So please feel free to go to our website at KeNIA. You'll be able to get more information about that. One last thing that I think Christian mentioned, which is very critical, is remember that as you register your IP, you'll be continuing with your innovation. You'll continue developing further your innovation. You just need to remember that if at all there's anything you've made adjustments to that you feel you need to protect, you need to go back and update that up until the point when they actually grant you that patent. You should be able to continue updating, because if anything you do not update and you have commercialized, and somebody is able to notice that you did not protect a certain element of you, they can easily duplicate. So it's all a matter of continuing to innovate. You should not stop. And as you continue to innovate, remember to update with the relevant organization. And for this case, it should be KeNIA. There's one last question. I'll just tackle that as we close, as I hand over back to Maureen. On trademarks and copyrights, has Kenya adapted the aspect of IP due diligence? Is there a checklist as is in the US and Canada? This would be yours, Brenda.
Thank you. So I don't know what happens in the US and Canada, and I don't know whether I will appropriately respond to the question because I don't understand what they mean a due diligence checklist. But what I can say when it comes to trademarks, although Kenya is a first to file country, someone can object a trademark registration if they have been using prior to the filing date. So you can use your common law rights of prior use to object the registration of a trademark. Copyrights, I think copyright is a unique aspect of IP. You don't need registration to have protection as long as the work has been transformed into a tangible form, then it is automatically protected. And Kenya is a member of the Berne Convention, so this can allow you to enjoy protection in other countries as well. But when it comes to enforcement, I find it is always good to just go to Kekobo and register your copyright. So Kekobo does not examine or anything, sort of a deposit that I came up with this song. I have written it, I've just put in it here for the record. I hope I have answered.
Thank you very much, Brenda. Thank you very much, Christian. We really appreciate the time we had to engage. I'd like to hand over this to Maureen. Over to you, Maureen.
Thank you. Thank you so much for tackling this session. I think for me, one key takeaway that has come out strongly is, as a researcher, when I'm going to register this IP, what is my IP and commercialization strategy? Because there's an element of, I am registering my IP, I'm going to apply, but what am I doing while I'm waiting that, I think Brenda said about 18 months to get the approval. What should I be doing? So two key things, of course, and everyone does this, we're advancing our technology, but then what about the commercialization? Who are our customers? Who are our intended, private sector engagement for it? Sorry, who are our partners in private sector? Who, in terms of policy, do we need to talk to the government at that national level? Do we need to talk to the government, perhaps at county level? I think that has come out very clearly, because most of the time when you go to register your IP, you're focusing on the technology that you need to advance. But there's also this element that you also need to be thinking through the commercialization. That way you're able to save time. When you get your approval, you're ready to move to the next step. So thank you very much for that. And just as a reminder, I think I'll just share my screen and make two quick announcements.
Maureen, remember to respond to one lady who had asked about R2C.
That's here. Thank you. So just two quick announcements. This webinar has been brought to you courtesy of ViKtoria Ventures, as well as KeNIA, Kenya National Innovation System. I think you have the websites for both organizations on the chat, so feel free to just read a little bit more about what is happening at both organizations. And then the announcement is the first announcement is we have our next webinar next week to just brainstorm through the value proposition. What is my value of my product? How do I, how do I sell my product? What is the value that the product or the research is speaking to? And that webinar will be on the 9th of February from 11 to 12, the same time as this one, East African time. And then the next announcement is that we'll be dropping a call for R2C TOT proposal, so training of trainers proposal. This essentially, as I said before, is looking to strengthen the institutional capacity to streamline research to commercialization process. So in terms of who should be applying, of course, it will be detailed in the proposal, but essentially it should be someone from an institution that already enables commercialization. So someone from an institution that perhaps has a technology transfer office, or someone from an institution that has relevant policies in place, is because, and the reason for this is that we need to, it's really for institutional strengthening. So we need to be pegged on an institution that is already working. And this could be a researcher, this could be a faculty, this could be management, this could be really any staff within the organization. I hope I have responded to that question. So thank you very much once again. Hoping to see you during our next session. And to our panelists, thank you so much, Christian. Thank you so much, Brenda, as well as Agnes, for moderating the session. I wish you a lovely, lovely afternoon. Thank you very much.
Thank you.